I'd like to welcome you on behalf of the Mercatus Center at George Mason University, where we are a academic research institution that believes in putting ideas into practice. And in that spirit, today we have one of our senior research fellows, Adam Thier. He's a senior research fellow specializing in technology, media, internet, and free speech issues with a particular focus in online child safety and digital privacy policy issues. He spent almost 2 decades in public policy research, previously as the president of the Progress and Freedom Foundation, director of telecommunication studies at the Cato Institute, and senior fellow at the Heritage Institute, and a researcher at the Adam Smith Institute in London. Adam is the author or editor of 7 books on topics as diverse as media regulation and child safety, mass media regulation, internet governments and jurisdiction, intellectual property, regulation of network industries, and the role of federalism within high technology markets. Please welcome Adam Thier.
Well, thank you, Aaron, and I really appreciate all of you coming out here today to listen to this talk about privacy in the internet, an overview of some of the key issues that you're currently facing right now in Congress and that we're debating more broadly in the academic community. What I'm going to do is go through a presentation which will start out as being, I hope, very an objective overview of the key issues currently being debated in Congress and in various regulatory agencies here and across the globe. And then as I progress, I'll get into more of a flavor for my own views on privacy policy and potentially an alternative way of looking at the issue compared to the popular trends out there today. So let me begin by giving you just a quick outline of the presentation. I'll go through a discussion about what we mean by privacy, different conceptions or approaches to defining or protecting privacy, the various trade-offs associated with privacy regulation. I'll talk about some of the unique challenges associated with trying to regulate the flow of information in our digital economy. I'll go through some of the specific legislative and regulatory proposals currently being debated, and then I'll talk a little bit about my own alternative vision, way of looking at these things. So when we talk about privacy, you know, it's a very thorny issue. It's a complicated thing. It can get almost metaphysical. You know, what is this thing we call privacy? And, you know, everybody has a different conception of it. It's a remarkably vague concept. It means very different things to different people, and it varies by culture. As I'm going to get to in a moment, you see very different conceptions of privacy, say, in many European countries than you do here and elsewhere. It also changes in response to evolving market or social norms as well as technological developments. And a really thorny question that comes up in the privacy context is if we define it or consider it to be a quote-unquote right, how does it play against other types of rights, or how do we balance it against other types of well-established rights, such as maybe freedom of speech or expression, which is something I'll get to later. So in the debate over privacy, there are a number of what I'll call sort of fuzzy concepts. Privacy itself can be subjective, but so too can be efforts to think about it in these contexts. First of all, what do we mean by harm? There certainly at the margins can be some clear ideas about privacy violations being harms, but how do you define and measure this thing that's so subjective? Is so-called creepiness a harm? We hear a lot about the concern about ads these days online being creepy. Is that a harm? How do we, again, measure that? Should emotional harms or feelings about things be actionable, legally speaking? You get to other questions like, what do we mean by ownership of private rights? There's a famous riddle that what belongs to you but people use more than you do? The answer is your name. And there are many facts about you that other people use every day, and they could be considered private, and yet they're also in another way public. So what do we mean by ownership? And what happens when data or information is shared information that 2 or many more people can own together? There's a question of informed consent. How do we have contractual relationships with this thing we call privacy? And also the very thorny question of what is sensitive private data. Clearly, I think there's a lot of agreement. Health-related, financial-related information can be very sensitive. But what else? Because there's a lot of other things people would like to throw in that bucket. I think it's helpful when thinking about privacy to talk about 3 paradigms that Alan Westin defined back in the late 60s about privacy. He talked about privacy fundamentalists, people who are almost absolutists about privacy being a right and one that trumps most other rights. At the other extreme are those that he called privacy unconcerned, which are people who have very little concern about who knows what about them, or just maybe don't think about whether or not it should be enforced. And in the middle you have privacy pragmatists, which are a broad group of people who would say when asked, I value privacy, but also understand the benefits of various types of information sharing. So we see these visions reflected in some ways when we talk about the United States versus the European Union as it pertains to privacy protection. We have very different paradigms, both in a social or normative sense as well as in a legal and regulatory sense when it comes to privacy in the US and the EU. First of all, the US traditionally has not viewed privacy as a fundamental right. It's not in the Constitution, formally speaking, and we see it in court cases, but we don't really hear it talked about as a fundamental right the same way we do in the EU, where it's considered a dignity right that is fundamental. In the US, our approach to privacy has been far more issue-specific or issue-driven or sectoral-driven, whereas you have a broad-based legal approach to the law in the EU. In the US, we have more bottom-up case law and torts to handle privacy violations. In the EU, it tends to be more top-down driven by so-called data directives. There's more of a focus on opt-out here in the States. You make the choice to get out of certain types of information collection. In the EU, it's more opt-in. You opt in before you release information. To the extent you hear concerns about Big Brother, at least till recently in the States, that's been more of a concern about government collection or aggregation of data. In the European Union, it's been both government and private sector, maybe in some cases more private sector concern about so-called Big Brother problems. So generally speaking, the United States has a more reactive regime when it comes to privacy concerns, and the European Union is more preemptive or even prophylactic in character. So here's what I mean by that US sectoral or issue-specific driven approach to privacy. This is just a sampling of some of the laws that we've passed in the United States since the early 70s, beginning with the Privacy Act of '74, having to do with government data collection and going on down from healthcare records and HIPAA, financial records and Gramm-Leach-Bliley. You had very narrow acts like the Video Privacy Protection Act, which dealt with whether your video rental records could be accessed by others. More recently, you had things like the Children's Online Privacy Protection Act, or COPPA, that I'll talk about later, and things like CAN spam and do not call registry. So when we move to the debate about online privacy, which is really quite hot today, we again wonder, are we going to get another narrow bill that deals with this particular concern? This is really a debate that's been raging for some time now, well over a decade. We got very close to seeing action taken by the Federal Trade Commission or even by Congress in the late 90s, early 2000s, but really was partially interrupted by 9/11 and a concern about how to fight terrorism and whether privacy was the right response, privacy regulation was needed at that time. There was also a movement made to give industry self-regulation, at least as it pertains to online privacy, a chance to work. So since that time and over the past decade, we've seen the framework that was developed at that time, the so-called notice, choice, access, security framework, these really four key prongs, really guiding a lot of what has generally been regarded as sort of a self-regulatory approach to online privacy and the rise of self-regulatory bodies and mechanisms and various technologies. And then, of course, that's been accompanied by targeted Federal Trade Commission and state-based enforcement at the margins for potentially egregious violations of privacy. So what are the new fault lines in the online privacy war? What's driving all the activity that you and your bosses are dealing with right now? Well, it's really being driven in large part by concerns about online targeting and or tracking and the so-called creepiness associated with the fact that a lot more data about us and our families is being ubiquitously made available on the internet, including by ourselves. And that's driving a lot of the legislation and a lot of the proposals you see here listed, including the sort of broad-based baseline approach that we see in bills like Kerry McCain and Rush and Stearns. And then there's more targeted things or mechanisms like the do not track mechanism or proposal that both the FTC has favored and that you see in legislation by Congresswoman Spear and Senator Rockefeller. You also have the do not track kids mechanism or measure that was recently introduced by Representatives Markey and Barton. And that would have a number of regulatory outputs. You'd have COPPA expansion. You'd have a so-called internet eraser button, which I'll get to in a moment. Restrictions on the geolocation data and its collection. You'd also have other things undertaken like data breach disclosure and potentially data minimization. The last thing on this list is a very, very important topic that I'm not going to spend any real time on today that deserves an entire course in and of itself, which is Electronic Communications Privacy Act and Data Retention Law. This is a hot issue, the question about how much data government collects and how it gets access to it, subpoena powers, really important issue. It's just a whole different world in of itself, but of course this is playing out at the same time this broader debate about privacy takes place. So let me turn now to some of the, what I call privacy trade-offs or opportunity costs in this debate that I think we need to consider before we go down the path of regulating more aggressively. I think what's really important to understand is that although the internet really does feel like the ultimate free lunch, and we get so many wonderful sites, services, and content free of charge to consumers, the reality is, of course, as economists always tell us, there is no such thing as a free lunch. There's essentially an implicit quid pro quo, as I call it, that governs online life, that you got to give a little to get a little, and in some cases get a lot for our money, or not our money, but the data that we trade. In essence, the internet is powered by advertising and data collection, and that includes data that's collected about us and our browsing habits or what we might like when we click certain sites online. That data is aggregated and utilized for a variety of purposes, sometimes just to make our browsing experience better, but oftentimes it's collected to serve up advertising that will essentially help fund the sites and services that we enjoy today. Let's face it, the reality is that all those searches we do really aren't free, and those social networking sites that we use aren't really free, and the content that we often view on certain news sites is not free. Something powers that. That something is advertising powered by data collection. In essence, information is used in lieu of payment. And what we have to keep in mind, I think, is that if we move forward with regulation, that could essentially break this system or that quid pro quo and have other unintended consequences that I'll get to in a moment. But before we get to that, let me just raise another issue, which is what I call the problem of information control. And this is a topic that my colleague Jerry Brito and I are doing a lot of work on right now at the Mercatus Center, where we're trying to point out that, privacy, I think a lot of us can agree, it's an important value and steps should be taken to protect it. But even when we agree on that, it will be very, very difficult. And the reason goes back to two famous quotes, I believe, from the oldest days of the net. Stuart Brand once famously said, "Information wants to be free," and John Gilmore noted that the internet interprets censorship as damage and routes around it. And the problem is they were both talking generally about things like copyright or about internet porn regulation, things like this. But this all applies equally to personal information. And that's an uncomfortable fact of life that once data gets out there, it's very hard to control and to regulate. And this is exacerbated by a number of unique factors about the digital economy and about digital economics, which is that you have these drivers of the digital economy, the fact that all information is being digitized into binary bits, ones and zeros, the intangibility of information, the fact that it's not physical, the fact that Moore's law, which represents, as you know, the falling cost of processing power, and the falling storage cost of the amount of information that can be easily stored now, and the rise of high-speed wireless and wireline networks. These things all facilitate some of these results I talk about on the right-hand side. Technological and media convergence, all media, all platforms coming together, information flowing over them. Decentralized distributed networking, very highly decentralized internet online networks. The sheer scale and scope and volume of online activity, which I'll put up some stats about in a moment. And perhaps the most interesting of all these problems is the one that we essentially have brought on ourselves through what I call user generation of content and self-revelation of data. We're putting ourselves and a huge amount of information out there about us right now. Here's just a few facts to give you a flavor for sort of what we're up against, or that last point that I made about user self-revelation of data. Every minute on Facebook, 100 million pieces of content served up and 650,000 comments posted on those 100 million pieces of content. That's every minute. Every minute on YouTube, 35 hours of video uploaded. Twitter has 300 million users producing about 140 million tweets a day, or a billion tweets every 8 days, which I did the math, I hope is right, equates to about 1,600 per second, 1,600 tweets per second. Apple has something like 3 billion apps that have been downloaded in its app store over 77 countries. And I could go on and on and on with statistics like this. Two computer scientists most recently tried to measure, this was really an audacious undertaking, all of humankind's sharing of information in recent years, and said in 2007 we shared 65 exabytes of information, which equaled the equivalent of every person in the world sending out the contents of 6 newspapers each day. Now, we're almost certainly not all sending out 6 newspapers each day, but what we're sending out is a lot of other types of data, and a lot of that data is data about ourselves, and some of it can be very personal, and we would consider it private. We also face this problem when we talk about user generation of data and self-revelation of data, of the fact that we have the so-called privacy paradox, which is that people always say they value their privacy, but that they seem to then go out of their way to often give it up, and we certainly see that on Facebook and other types of social networking sites. And that's often because sometimes we don't understand the downsides of that data release. We don't understand the ramifications. Other times it's because we do understand there's a trade-off, or there's some value to giving up some information to get other types of services or to make our lives easier. Regardless, I think what these factors tell us is that we have to learn to accept the fact, as David Friedman, a lawyer, David Friedman, says, that once information is out there, it is very hard to keep track of who has it and what he has done with it. And this doesn't mean, as some people say, your privacy's dead, get over it, but it does tell us that we live in a different world than we did in the past, and the challenge we face is going to be far more significant. It also tells us that I think rushed, heavy-handed type solutions are going to be extremely costly and difficult to enforce, and perhaps not as effective as we'd like. So with that, let me turn to some of the policy responses we're seeing to privacy concerns, and then I'm going to outline a couple of the downsides of some of these proposals. So first we have the so-called do not track mechanism, which has gained a lot of traction at the Federal Trade Commission after it released a major report earlier this year on privacy. This could be a voluntary approach, but it also could be mandated by legislation currently pending in Congress or by FTC action. And it essentially would demand excuse me, that websites honor a machine-readable header in the browser that would allow a user to indicate they don't want to be tracked online. They don't want to have information collected about them when they visit certain sites, whether that be for advertising purposes or whatever else. The question is, how far would that apply? We're not quite sure yet. And in theory, at least, that would allow very privacy-sensitive users, or those so-called privacy fundamentalists, to take steps to signal to sites, hey, just bug out, I don't want having information collected. So what are the trade-offs here? Again, there is no free lunch, and I think we do have to ask, if this sort of approach is put into law at least and mandated, there's a question if that quid pro quo I talked about is broken, and that essentially something has to give, and that something could be price, or it could be quality, or it could be quantity, the three leading economic variables that all economists consider. It could result, for example, in paywalls going up or higher prices for services we currently pay nothing for. It could result in less relevant or even more intrusive forms of advertising to replace more targeted ones. We could see more banner ads or what's called interstitial advertising, those things that pop up and say, wait 30 seconds before you go forward, and we may have a lot more of those. Or we could just have fewer services or less types of content, including media content, or it could, again, go behind more paywalls and more charges to consumers. There could also be an impact on international competitiveness. I mentioned earlier that the US and EU have gone different directions on privacy, and there have been some economists who have suggested that this has had a resulting impact, and a deleterious one, on EU companies. Goldfarb and Tucker had a study recently, the MIT economists, basically saying that advertising effectiveness decreased on average around 65% in Europe following the imposition of data directives there in early 2000s. And they pointed out that because regulation decreases advertising effectiveness, that, quote, this may change the number and types of businesses sustained by advertising-supported internet. What they mean, to put it in simple terms, is that, again, there is no free lunch. There are trade-offs here. By making advertising sort of less contextual, less relevant, it's been harder for them to attract more money through advertising for sites and services, and that's had a deleterious impact on the various types of outputs you see in Europe relative to the United States. It also might explain why some of the world's best leading internet companies come from the United States, but that's a more contentious matter. Another question about do not track is simply, is it practical? Does do not track scale? Will it apply to international types of operators or companies that might operate outside our laws? Will it apply to other devices? How will it work with all the various digital devices in our lives? And then finally, there's a concern about regulatory creep. Will this become a model for other types of internet regulation, especially sort of speech control regulations that some of us would be very concerned about? I don't know for sure, but it certainly could create a new regulatory entree for those who would want to regulate other types of information. Let me talk a second about the Children's Online Protection Act, Privacy Protection Act, or COPPA. Basically, COPPA was passed in the late 90s. It was the first attempt to deal with the special concerns about youth and online marketing and data collection. This mechanism requires so-called verifiable parental consent, before a site that is directed at children can collect any information about them. It's a tricky matter about how this is defined, but it applies to only sites that are directed at kids 13 and under. And the FTC defines a set of rules through a so-called safe harbor provisions that will define when it's okay for companies to move forward with some certain types of data collection about the 13 and under crowd. The important thing to keep in mind about COPPA is that it's never been constitutionally challenged. This is very rare in the field of internet policy and cyber law. Almost every law has been challenged in this area. This one is not. So it is a template potentially for reform and expansion, which gets to the questions about what are the potential downsides or problems we face when we try to expand the COPPA model, as right now Representative Markey and Barton are proposing. Well, in simple terms, what works for the under 13 audience might not work for all teenagers and all other parties. Basically, by moving away from 13 and under, sites that are directed to that, we have to then ask, how do we know people are 15 or 17 or 40? And shouldn't belong in a certain site or should receive parental consent before data is collected. The answer is the only way we'd find that out is to have mandatory age verification. And that's something that's been litigated under a bill, under an act called COPPA, not to be confused with COPPA. COPPA was the Communications Online Privacy Protection Act, and it passed about the same time as COPPA, but it was constitutionally challenged because it basically required online age verification before accessing material that could be considered harmful to minors. So it was an attempt to deal with online pornography. This led to a stunning, epic 14-year legal ordeal, back and forth, with 3 trips to the Supreme Court, all of which resulted, to make a long story short, in the courts saying at every level the law was unconstitutional because mandatory age verification of individuals online would affect far more speech and far more parties than just children. And that would have a potential chilling effect on who would go where, and it also raised practical questions about does age verification online work, and they said no. But the fundamental point that I want you to take away from this discussion is that expanding COPPA to make it more like COPPA raises these free speech concerns and some of these sensitivities about age verification, which a lot of people are very troubled by. And most ironically, as I point out here, in the name of protecting privacy, potentially more information would potentially need to be collected about individuals to verify who they say they are before they or their children go online. Let me move to the internet eraser button concept and just very briefly mention this. This is an idea that's gaining a lot of traction, both here and overseas in particular. In Europe, this is called the right to be forgotten online. And the goal is to make it easier for people, especially kids, to delete comments or other types of content they had posted but then later come to regret. The practical problem with this, and there are several, first of all, what is this button? A lot of people think of it in a very simplistic terms like it's the Staples Easy button that sits on your desk that says sort of delete, delete. It's not quite that simple. It's especially not that simple because it's not clear where it's at, who controls it, what happens if the information is shared, has been replicated in other areas. All of you probably have Facebook accounts and maybe put photos up, and you and some of your friends are in both those photos, and they might produce it on their site and save it elsewhere. You might tag their photos. They might tag yours. Who owns that stuff? Who gets to decide, well, I'm embarrassed about that. Now I want to delete it because I'm in the corner of that picture, and I don't like the way I look in a swimsuit. So if it's not your photo, that raises an interesting question about ownership and if you have that right. There's a more principled problem here that I think is really concerning, which is when you talk about an eraser button for the internet, you're talking about an effort to essentially censor something that's already been put online, something that could be a fact. And it could be that, well, we don't mind censorship in the context of privacy because it's about personal information. But of course, this raises some rather sticky free speech issues, especially press freedom issues, because there's a lot of information that does appear online that later we might want to remove, but it's not easy. And if we did, it would require essentially shutting somebody else up or taking information away or facts away from them. This is a huge problem in Europe, where they have actually laws in some countries, including Germany, for example, that says that after you've been a convicted felon and gone and served your jail time and get out, the press is not supposed to report on your crime anymore. Essentially, you've served your time, you're done. They don't want that social stigma following you around in Germany the rest of your life. They want to give you a second chance. In one sense, we could say that's noble. On the other hand, what if you're a journalist writing a book about someone who was accused of a crime, maybe even killed somebody, and then later got out? That's technically illegal in Germany. You can see how under our First Amendment in the United States, this could create some real serious tensions for journalistic and press freedoms. So those are just a few issues to consider about the eraser button, which again is in the Markey-Barton bill and is starting to get a bit more traction. Now I want to talk to you finally about a different vision for privacy regulation and privacy issues that gives you a different feel for a way to look at this that is perhaps a little less inclined to regulation, a little more towards market mechanisms. So there's been a long-standing conflict, visions if you will, when it comes to risk regulation in our society, in any context, environmental context, financial context, anything. There's this vision about how to best manage risks between those who have more of an anticipatory mindset versus those who are more focused on what I call resiliency. And this is really based on a framework developed by a great political scientist in the 1980s named Aaron Wadolsky, in a book called Searching for Safety. And in the anticipatory mindset, the focus is very much on prevention. That's the prime value. And a focus on what's called the precautionary principle, which is not allowing progress or developments or things to happen until we've made absolutely certain that no harm could come of that development or progress. Then there's a different approach, a resiliency-based approach that's focused on experimentation and evolution and learning as the prime value, with a focus on how we cope with technological change or changes in our society. And you very much see this at work in the United States versus Europe, but I would say you see it at work in a lot of the proposals that are out there today in front of Congress, with a heavy anticipatory approach to a lot of these things, with a suggestion of something like mandatory do not track or mandatory opt-in for all data collection. Whereas a different approach would say, well, maybe we should try to experiment with do not track at the margins in a more voluntary sense, and offer opt-outs for people who don't want to be tracked. That's a market norm or a social norm that would be nice to develop. The anticipatory approach on apps and functionality might potentially ban them preemptively or heavily restrict them until we can make sure there's no showing of harm. Whereas the resiliency approach would say, no, let's allow for this sort of experiment to continue with apps and technology, even if there are some privacy concerns, and so on and so forth. The anticipatory approach probably favors an eraser button mandate, says let's go ahead and do it, see what happens. Those of us who are more in the resiliency camp would say, you know, maybe we could try voluntary efforts to purge data and to have what I call better data hygiene, encouraging people, including kids, to be smarter about the information they post online. A school system in New York really had a very innovative thing recently where they had delete day, and they brought kids to the cafeteria and encouraged them all to go on their accounts, delete things that they didn't think were necessary or were embarrassing or potentially hurtful to their fellow students or colleagues. That's a really interesting approach, again, based more on resiliency other than coming in and preemptively trying to deal with it. So let me lay out for you how this plays out in terms of sort of constructive alternatives to some of the regulatory approaches we see out there today. This is my sort of five-part approach to these things, and it's the same approach I use for child safety issues as well online. First, I think we need to be very careful about how we define harm and market failure, and don't lower that bar too much. I think creepiness, for example, can be concerning about data being collected, but is creepiness really a harm? I think in most cases it's not. But something like data breach, what happened with PlayStation recently, I don't know how many of you got hit by that attack like I did, but you know that there was a clear harm there, and there needs to be steps taken, at least better notification made by those companies when these things happened on a more prompt basis. Second, more broadly, and I'm going to elaborate on this in a second, I focus on what I call the 3E solution to a lot of these problems about online privacy and child safety, of education, enforcement, empowerment, and targeted enforcement. Again, I'll get more to that in a second. Third, we need to better encourage corporate and personal responsibility when it comes to online privacy. Fourth, I think we need to continue to think about privacy as an evolving set of social and market norms and interactions and experiments as opposed to a rigid concept with a clear endpoint. And I think fifth, and I'm going to repeat this again at the end, you know, we just need to make sure we don't engage in a techno-panic mentality here. I think we can and have learned to cope with privacy, with changes in our society and its impact on privacy before. The most famous article ever written in the United States on privacy, called The Right to Privacy, was written in 1890 by Judge Brandeis and another gentleman, Warren. And Brandeis and Warren, you know, their concern in 1890, and the reason that they articulated their concerns about the need for a right to privacy, and a whole body of law evolved from this law review article, was that Judge Brandeis was really upset that the Washington Post had the audacity to send a photographer to his daughter's wedding and take pictures and run them in the paper. He was very concerned about this new company called Kodak. So, you know, we kind of got over that, not entirely. We still have concerns about paparazzi and too many photos, especially of kids. But the reality is that, you know, he's a public figure. It was a very public wedding. And our society changed. And we have different norms now dealing with photography, including of people in public, especially public figures. So let me briefly just mention what I mean by this 3E solution. The first E of which is education. And this is, I think there's a lot of agreement that this is a good approach, no matter if you believe in a more anticipatory approach to regulation or the more resiliency-based approach that I favor. Education, we need it at all levels. We need better awareness and awareness campaigns by privacy advocates, by government, by industry, educators, and so on, to encourage better online netiquette and behavior. And again, that term I used of data hygiene, learning how to be smart about what you post online. It's very important we teach our kids this. And we need a better push for transparency across the board. Generally speaking, the more disclosure, the better notice and labeling about how data is used, what it's used for. I think online companies have done a very poor job so far of informing their consumers of why they're collecting data, what it's used for, how it potentially benefits them. Because once they tell the story, it's a pretty compelling one. But I think a lot of them themselves have been creeped out, that other people will be creeped out once they know we're collecting this data about you. In most cases, it's not a complete digital dossier, as some people fear. It's really just some basic information about you and your browsing habits to make your internet experience or your experience on that site better. So the second E is empowerment solutions. And this is just basically about helping users better help themselves. User self-help tools and empowerment tools are multiplying in the marketplace today. It's a really great news story. I mean, AdBlock Plus, which blocks all online advertising and tracking, is the #1 most downloaded tool for both the Firefox and Chrome web browsers. The #2 or 3 downloaded tool on both those sites is NoScript, which blocks scripts that run that basically can provide online video but also collect data through flash cookies, things like that. And then there's a host of other browser tools in every major browser that allows for cookie blocking or for tailoring of your privacy settings. These are wonderful tools. In fact, I've made the argument in one of my recent books and in a child safety task force that I served on that the tools that exist to empower individuals on the privacy front are actually better than the tools that exist on the child safety front. That they actually do a better job in some ways of blocking content or blocking data access or data tracking than things like, you know, the V-chip or filters when it comes to blocking pornography. That's a contentious and a controversial statement. A lot of people disagree with me, but I think these tools work marvelously. It's just that a lot of people don't like to use them because they can be an inconvenience. They can block a lot more than they want blocked. Anyway, the final prong of empowerment has to do with industry self-regulation, which is the need for, again, more transparency, better online industry practices, self-regulation through industry codes of conduct and seals of approval, and a lot more collaboration about how to give users more choices when they're online, and better defaults about what happens when they first go to a new site or service, and telling them more about what happens there. The third E is enforcement. And this is basically holding companies to the promises they make. And the good news here is that the Federal Trade Commission already has the power, and I think should step it up, to enforce its Section 5 authority, which has to do with unfair and deceptive practices, for those companies that blatantly violate promises they've made to consumers based on privacy or data collection. And the FTC has been doing a lot more of this lately. You may have heard of some of the settlements having to do with Google and Buzz. You may have heard of some of the COPPA-related things they've been doing and some of the other settlements they've made through the years with Sears and other companies saying, you promised you weren't going to do this with this consumer's data. You did it anyway. You sold it to a third party, or you used it to do something that was even more egregious, and we're now going to fine you for that. I think that's fine. I think that's part of dealing with what is potentially fraudulent activity or, again, unfair and deceptive activity. The other part of enforcement is, again, I'll just hammer on it one more time, demanding better notice and transparency. And this may include mandates for disclosing what kind of data is collected. And it certainly should include a mandate to disclose any sort of data breach for information about consumers that gets out. It's a question of how long they should wait before they disclose. But I think the fact that they should disclose is unambiguously agreed upon. And then potential targeted regulation of sensitive data. This is a very contentious issue, but medical and financial information, there's no doubt about it, it is more sensitive. And a lot of people want different rules for that class of information. And you know what? We have those rules. We have things like HIPAA, we have Gramm-Leach-Bliley, and we have other types of things that deal with particularly sensitive forms of data. But even there can be benefits to, for example, searching for certain medical terms or conditions you may have and being able to getting targeted information. Now, if you get back after you've searched for herpes, something about a bunch of herpes ads, you're probably going to hit the panic button, or that you want to hit that eraser button. You don't want that to get out to anybody. That's where that sensitivity comes in. But you can also think about examples in other contexts where searching about certain conditions gets you better targeted advertising, or maybe just more information from the online company you're dealing with about your condition or about the issues you're concerned with. So let me conclude just by reeling off the key takeaways I hope you walk away from this talk thinking about, which is, again, privacy is an incredibly complicated and contentious issue, a very subjective condition. It can and often does conflict with other values and or rights. All regulation entails trade-offs and cost, and there is no such thing as a free lunch, except for the lunch we provided you here with today. Perhaps most importantly, information control is very, very hard, and getting harder with each passing day as the volume of information increases. And there are no silver bullet solutions. There's no quick fixes to these problems. You need a layered approach that's focused on education and transparency. And I would really hope that we focus more on resiliency and coping with change as opposed to trying to stop it through preemptive, heavy-handed regulation that anticipates every harm or tries to stop all progress before it happens. And finally, just with real emphasis, let's not panic. We don't need to have a techno-panic about privacy. I think we can cope, we can get through and adjust to these changes with some potential minimal action at the margins. So with that, I'll wrap up, and I welcome any questions that you may have, and I hope you found this informative. Any questions? Wow, I've wowed you or put you to sleep. I should mention at the back page of the presentation, I have a list of further readings from the Mercatus Center on these issues, including some recent Forbes columns I've written on this, and some longer papers having to do with privacy regulation. Sir, do you have a question?
Yeah, with the recent news, I guess, about Apple and to the extent to which their iPhones and iPads and stuff are collecting data, given your take on how to address some of these privacy issues, for you, is it more of an issue of addressing the situation by, I guess, greater enforcement of whatever commitments Apple made to their consumers when they bought them, and then also maybe at the same time just a better education to consumers about what they were getting themselves into, or were they in fact stepping over the line of what they should have been doing?
Yeah, so as a threshold matter, the first question I ask when I hear about sort of the concerns that have been raised about the geolocation, the collection of geolocation data, is there a clear harm there or market failure that we need to address? To the extent that there is, I don't think it's a real serious harm to consumers. I think the problem there is the lack of informed consent or the lack of information about what was happening. And again, this goes back to the fact that I think a lot of companies have been a bit concerned about, well, if we try to lay out a bunch of examples of what could happen about your data collected online from geolocation, that'll just creep people out. They'll get scared off. They'll never use this service. Instead, what most companies have, including Apple, is when I'm sure you've downloaded apps on your phone or on other services, you get a brief warning saying this application will seek to access your GPS data or your calendar or your whatever information. And it sort of bullets out what kind of information might be collected. And what it doesn't probably do good enough is then explain to you what will happen with that information or how long it will be retained. Now, at some point, the problem is consumers don't want that litany, that legalese that runs for 8 pages, because then you have the click-through. People say, oh, yes, let me get that app downloaded now. And they click right through it. So this is the real challenge. We face this both in the privacy context and the child safety context, about better notice, disclosure, and awareness without overwhelming people. Because there's this trade-off between being comprehensive about what you reveal and the complexity of what you reveal. And again, there's not an easy solution to this, but at the end of the day, I'd like to find ways, and I would I don't think they need to be mandated, but some disclosure might need to be, for companies to get better about educating consumers about what information is used for and explaining to them in most cases you probably don't have much to be concerned with, but then also giving them the option to say, but if you are concerned, here's the way to just opt out of this, kill this service, delete your cookie, whatever it may be. But here are the trade-offs. If you do that, you might not be able to use this service. So it's really complicated with geolocation. Other questions? Sir?
I don't know how much of the Senate legislation you've read through, but do you know, could you explain the data breach disclosure Kerry McCain bill and what that does?
Yeah, I'm not familiar with all of how the legislation deals with all of these issues, but generally speaking, there's a move afoot, and I think it's probably one that will be one of the less controversial elements of these bills, to have a requirement such that there is some sort of data breach at a company, an organization, that they notify their users, potentially via multiple ways, at least via email, but maybe more other steps, letters, calls, that X has happened and Y could be the consequence. And then there's also a penalty associated with a refusal to do this or an inability to get the information out on a timely basis. So with the Sony breach, one of the concerns was that, okay, well, why did they wait this long? Why did they wait so many days? And there is a good response on one hand, which is, well, at first, maybe the company's not even aware of what happened and is unsure. They don't want to panic everybody into thinking, oh my gosh, all your data's been compromised, if it hasn't been. Now, in this case, it was. And a lot of really important information, including things like, username, password, stuff like that, highly sensitive stuff. And that's deeply troubling. And it made those of us who have and love our PlayStation 3s, or made our lives a real hell for a while because we had to change all our passwords. We lost all our online services. So it's going to hurt Sony, and there will be a penalty they'll pay in the marketplace. The question is, will they need to pay a penalty in some other fashion to the government or consumers for what has happened here? They've gone out of their way to promise that there are going to be a lot of free movies, free games, free online time as part of the compensation. But there's already been class action launched. And again, that's another way to deal with privacy or data breaches. But I think it's an unambiguous good that we get more information out to consumers through disclosure policies. And I think that'll probably be one of the, again, least controversial and most likely things to survive in a legislative comprehensive bill if privacy does see passage this year or next. Any other questions? None?
All right, well, thank you so much for joining us today, and thank you,
Thanks a lot.
Adam.